You're appearing here today.
By special appearance.
I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
And child subject matter jurisdiction, going on record.
Okay, what does that mean?
Overstand.
You just determined to use different words and be difficult, aren't you?
All right, next cases the court's going to call will be State of North Dakota versus Michael Scott Jakey, CR 36, CR 16, and 26, CR 50. Present in court, Attorney Mary Depute for the state.
I'm here by special appearance as the executive.
Please have a seat. Please have a seat. Mr. Jacobson is personally present and without counsel. Sir, good morning. Were you present in court when your rights were read to you earlier?
Sir, I don't consent to this hearing because of lack of jurisdiction of the court over me. I'm not a 14th Amendment citizen anymore. And it's in my documentation that no one ever reads.
Sir, I asked you a question.
I told you.
So,
I am not,
sir,
I'm not.
sir,
under your
stop
jurisdiction.
talking over me. I'm going to ask you a question and you're going to answer the question.
I don't understand.
So I'm asking you, were you here when the rights video was played not once, but twice this morning?
I was here.
Do you understand the rights as they were read to you?
I don't stand under anybody.
I'm asking if you understand the rights that were played for you.
I don't understand.
Okay, so let's talk about what you do and don't understand, sir. Do you understand the English language?
You do not have jurisdiction over me. If you look at the documentation,
Answer my question, sir.
you do not have jurisdiction over me.
Answer the question, sir. Do you understand the English language?
I don't understand.
Okay, so I'm asking you if you understand the English language.
I don't stand
So-
under anybody.
Sir, I'm asking you if you understand English. I asked the question in English. You responded in English. I think you understand,
Your answer.
but I'm making a record, sir, to make sure that we're clear.
My record is you don't have jurisdiction over me.
And,
I'm not a 14th Amendment
Sir.
citizen or resident.
sir,
You even know what I've done? I've changed my jurisdiction. I've gotten out of the jurisdiction of the water and I'm back on the land where
sir,
I'm alive. I'm a living, breathing soul. And you cannot contract with me anyways.
yeah, I'm not contracting with you at all. I'm asking you if
That's
you
what this court is trying
Sir.
to do.
Stop talking out of turn. Are we clear? I'm asking you, do you understand the English language?
You've answered that already.
So your answer is yes, you understand.
You answered it.
I'm asking you to answer it, sir.
You've answered it yourself.
It's not for me to decide. It's for you to put on the record whether you understand the English language or not. Do you understand what I'm saying to you?
I don't stand under anybody.
That wasn't the question.
We're not going to get anywhere. You do not have jurisdiction over me.
Sir,
If you had read my affidavit,
were you present in court when your rights were read to you earlier?
I've been in court many times and I've heard those rights.
And so you understand those rights.
I don't stand under anybody.
That wasn't the question. Do you understand?
That's what you're asking me to do. I don't stand under you.
Sir, you've already said you made a special appearance. So I'm asking you if you understand. Do you understand?
I comprehend them.
Okay, comprehension is good enough. You comprehend them. All right. Do you comprehend that you have the right to an attorney?
I don't need an attorney.
Do you comprehend that you have the right to either an appointed attorney if you financially qualify for one, the right to hire an attorney of your choosing, or the right to represent yourself if you can do so knowingly, voluntarily, and intelligently?
I don't consent to this hearing because I'm not under your jurisdiction. I'm
Sir?
under the jurisdiction of the land.
I
Not in the
understand.
jurisdiction of,
Sir,
of your contract law.
okay. Do you comprehend your rights to an attorney?
I don't need an attorney.
Has anyone threatened you, forced
No one has
you?
threatened me.
So let me finish before you start talking. Sir,
I've been here the last 7 times.
stop.
Nothing has happened. Read the
Stop.
file.
Sir, stop interrupting. Stop trying to talk over me. I'm asking you a question. Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to an attorney?
No one has.
Thank you. So we are here today for a number of dispositional conferences. A dispositional conference is a conference set to determine how you intend to proceed.
Your Honor, if I could interject, I'm sorry, but I think there's a little more complexity to this procedural posture. In case 16, the defendant had filed a motion to dismiss. The motion to dismiss, the response was filed with the state on June 28th. At the last status conference, the defendant wished to raise the same motion in all three of his cases. At that time, it had not been served in the two remaining cases. Although the motion still has not been served, it has been filed in the two remaining cases. And so I believe that there is a pending motion before the court in all three cases.
So this wasn't noticed as a motion hearing. Rule 3.2 requires that the moving party file a notice of motion declaring whether or not the motion is to be heard for oral argument, to be heard for an evidentiary hearing, or to be considered under briefs. That notice of motion wasn't filed, requesting a hearing. So today it's not properly before the court, even if it was properly served.
I brought it to the clerk's
Sir-
court. I could not get a hold of Ms. Pugh. She would not.
So
return my
stop.
calls.
This is where I'm talking. So those motions have not been served. So technically, even if the state's filed a response, they're not ripe for the court's consideration. So the court is not going to take up motions. Furthermore, these are Judge Naram's cases. I'm not going to rule on motions in Judge Naram's case or cases that are not properly before the court and noticed for hearing. So as far as the court's concerned, all that's before it today properly is a dispositional conference. Sir, you have 5 options at a dispositional conference. You can schedule it for a jury trial. You can request a bench trial. And if the prosecutor agrees and the court agrees, the court can schedule it as a bench trial. You can request a continuance. You can change your pleas from not guilty to guilty today. Or you, lastly, can choose to schedule a change of plea for a later date.
Well, let's do a continuance until Judge Naram gets the case so he can make a decision on it.
All right. So what I told you before is right now those issues aren't properly before the court because they haven't been served properly following the
We'll
rules.
serve him properly. We'll just do a continuance then.
All right. Ms. Depute, your thoughts?
That seems appropriate to me. I believe at the last, maybe there are not notes on the docket. I believe it was contemplated by the previous judge that this would be a motion hearing. It was discussed at that time. The state is ready to proceed. But if Your Honor doesn't wish to hear it today, then I believe continue it until Judge Naram could hear the motion would be approved.
So Judge Naram's next court date in McIntosh County is 6 weeks away.
That'll be fine. We can't get nothing done if there's another judge here. Got to have Judge Naram.
Well, he's assigned to these cases, and typically once a judge has been assigned, unless there's an agreement or stipulation between the parties, I'm not going to sign a motion or consider a motion that wasn't on the docket as a motion hearing. So I will continue this matter, all 3 matters, for a dispositional conference and a motion hearing for November 13, 2023, before Judge Naram. It'll be set at 9:30 a.m., but I'm sure Judge Naram will call that case last. Just so you're aware of that, Mr. Jacobson, it probably will be late morning before that motion is heard. Ultimately, Judge Naram will be able to decide the motions, assuming that they are properly before the court at that time. And so that means proper service, proper notice of motion. You'll need to file a 3.2 notice of motion that declares whether it's for evidentiary hearing purposes, oral argument hearing purposes, or both. And at that time, Judge Naram can make decisions. So that'll be the decision of the court today. Continuance in all 3 files until November 13 before Judge Naram. at 9:30 a.m. Anything else, Ms. Depew?
To clear up part of the record, in case 16, it was noticed as a motion hearing. I understand the judge's ruling. I just want to make sure that what's represented is correct. But other than that, I have no further comment.
Yeah, because I remember him telling me to file motions for the other three, because he put them all three on the same day.
Yeah. So as a matter of judicial economy, even if it was, it's not in Odyssey. The code that I was looking at isn't in Odyssey saying that it was a motion hearing, but in the Odyssey record, it just says misdemeanor dispositional conference on file 16. On the others, it has not been cleared up. So in the interest of judicial economy, those will track together if it's the same motion in all three files. So, all right, with that, we're adjourned in this matter. Thank you.
Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry, speak up so I can
Here
hear you.
today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity, not said right.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nasir Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you've now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
I got the child subject matter jurisdiction going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
This is what I'm saying.
Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about.
Yes.
So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk.